大家好，我是阿乐，
我是阿伟，又来到我们1月1课题的乐伟小讲堂。
今天的课题是什么呢？
写了遗嘱，当然是要知道应该怎样保管它。
Oh yeah， 出发吧！
冲啊！
你知道大家通常都喜欢把遗嘱收在哪里吗？
哦，简单啊，这种这样重要的东西，当然要放在家里的保险箱啊。
错，你试想看，万一有一天你不在了，你的家人会知道你保险箱的密码吗？又或者，如果你的保险箱遭偷窃了，你的家属在找不到你的遗嘱情况下，只好根据1958年无遗嘱分配法令来分配遗产，完全不能依照你的意愿分配。
那我要快点把我的遗嘱拿出来了。
那放在银行可以吗？
当然也不可以呀。一个人死后，所有的资产，包括你在银行里的户口，都将遭到冻结。而这些冻结的资产，只有遗嘱执行人或无遗嘱遗产管理人才能够打开。然而，家属在找不到或无法取出你存在银行的遗嘱下，将自动定义为你并未撰写任何遗嘱。那么，遗嘱执行人的委任过程将不存在，而你的遗嘱内的意愿也不能实现。这样，你所写的遗嘱不就等于没写了吗？
哦，真的？那我不是要快拿出来？
既然如此，那最好的方法就是交给家属保管了。
No， 遗嘱是一份极其私人与保密的文件。你把遗嘱交给家属们，那你是否有信心你的家属不会打开来看呢？假设你遗嘱内的指示是把整间屋子给你的小儿子，而你的大儿子却什么也没有分配到，他会不会企图篡改或伪造一份新的遗嘱呢？
果然在钱面前是没有亲情的呢。哎呀，我知道了啦，我自己收不就好了嘛，把它跟我其他一些重要的文件放在一起就好了。
这是最容易搞丢遗嘱的一种做法。你可能会忘了你把遗嘱存在哪里，又或者被你的家属找到并篡改，再或者遇到一些像淹水或火灾的事故。假设这些不幸的事情发生的话，那你的遗嘱不就等于白写了吗？
等一下，你们讲了这么多，那我们到底要把遗嘱放在哪里才叫安全呢？
对啊，那可以放在哪里？要放在哪里嘞？
那要怎样啊？
那当然是乐伟遗嘱保管中心啊！
将遗嘱保管在这个中心，你将能够确保你的遗嘱在需要的时候能被寻获，极具保密与安全性，防止篡改，并享有申请遗嘱认证文件时的补贴费用与乐伟意外死亡福利。
哇，好像很不错耶。
真的呢。
That's good。
这样我先走喽。
我也要。
我可以跟吗？
虽然善写遗嘱很重要，但保管好您的遗嘱也是重要的一环哦。
对呀，要不然到头来就等于没写过遗嘱一样，那您的意愿不就不能实现了吗？
好啦，快乐的时光总是过得特别快，又是时候说拜拜啦。
我们下期再见，
拜拜。
乐伟，让您的意愿得以实现。
Estate planning gone wrong, giving too much too soon. It is good that we plan ahead to put our affairs in order before our departure. However, doing it yourself without professional help can be tricky. Estate planning can go wrong without proper guidance. Meet Tom. Tom was a single parent with 3 young children. He worked very hard as a businessman to make sure he can provide for his children, even when he is no longer around. In his will, he left his 10 million ringgit worth of assets to his 3 children equally. When he passed away, all his children were young adults in their 20s, receiving a large distribution of cash. They became millionaires overnight. However, their joy was short-lived. Within a year, Tom's eldest son crashed his brand new sport car on the highway and became paralyzed. Tom's daughter was cheated of a few million ringgit by her con artist boyfriend, left with a broken heart and no money. His youngest son became addicted to gambling. One day, he blew away his entire inheritance in a casino and became broke overnight. In hindsight, what could Tom have done to avoid this from happening? While alive, Tom should have given directions on when, and under what circumstances his children may receive their inheritance. For instance, getting a monthly allowance until they are old enough to take care of their own finances, after getting a degree, or reaching a certain age. If Tom had included a testamentary trust in his will, he would have ensured that his hard-earned assets are well preserved and then passed smoothly to his beneficiaries at the right time. The biggest estate planning mistakes can be easily avoided by leaving the matters to the right professionals. At Rockwills, we offer customized will and trust setup services, tailor-made according to your needs and concerns. To date, we have written more than 250,000 wills and set up more than 10,000 trust deeds for our clients. Check out our website or speak to our estate planner today to find out more. Promoting Rockwill's lifetime estate planning nightmares. Estate planning sounds like something remote that only wealthy people do. We often think, I don't have much that is worth the trouble of going through estate planning. Well, it is not true. Here are 2 stories that might make you think twice about not having a proper estate plan. The unmarried widow. Eddie and Ella were living in Eddie's bungalow together with Ella's children. They were not married, as Eddie was still badly affected by his recent divorce. Unexpectedly, Eddie died in an accident. Ella was horrified to find out Eddie had not written any will. In absence of a lawful marriage, Ella and her children were not able to inherit anything, as they were not the legal beneficiaries to Eddie's estate. Eddie's estranged son from his previous marriage became the rightful sole beneficiary to the estate, including the house Ella and her children were staying in. As a result, they were left homeless. The withered Ivy. Ivy and her son stayed in the house bought by her and her late husband. Ivy thought of leaving all her assets to her son eventually. However, being superstitious, Ivy was against the idea of writing a will, as she thought it might bring bad luck to the family. Instead, she transferred the house directly to her son. After a few years, Ivy's son got married and continued to stay in the house. As their family grew bigger, her son and daughter-in-law decided to kick Ivy out of the house which was rightfully owned by him, to make space for their new family. Filled with regret and disappointment, Ivy was forced to move to a nursing home for her remaining days. These real-life nightmares happen to some of us more often than we might think. Avoid these by setting up a will or a trust. At Rockwills, we offer customized will and trust setup services according to your needs and concerns. Visit our website or talk to our estate planner today to find out more on how you can protect your loved one through a complete estate plan. The convenience of Rockwill's custody.
是否需要一份信托？
Planning for your digital assets. It is good that we plan ahead by writing a will to leave our affairs in order before our departure. In the will, we usually include all our important assets, such as our house, cars, or even personal collection and jewelry. However, what about our assets that are embedded in the digital world, the digital assets? In the digital age we live in, digital assets become increasingly important. It can range from monies in e-wallets and online bank accounts to social media accounts like Facebook. Meet Gary, a young entrepreneur who has invested part of his fortune in Rockwill cryptocurrency and earned millions out of it. This cryptocurrency has become a significant part of Gary's wealth. And Mindy, who loves posting her photos, videos, artworks and writings on her social media accounts and blog. Those digital assets offer incredible sentimental value for her and her family. What can they do to protect their valuable digital assets? Estate planning on digital assets can be very tricky, as they are different from our traditional assets, such as bank accounts and properties. Even more so, digital assets are usually built around very tight cybersecurity measures that are designed to prevent unauthorized access, other than from the owner himself. Therefore, overlooking your digital assets in the will without leaving proper access information could leave your executor not having access to them. Including access codes or passwords into the will is also not an option, as some may have access to the will either before or after your death. Without a proper estate planning, all these digital assets might be locked away permanently and lost to your beneficiaries. At Rockwills, we are the first in the industry to have innovated a way to include your digital assets in your will. It will ensure your valuable digital assets are accessible by your beneficiaries even when you are not around, at the same time preserving your confidential access. Visit our website or contact our estate planner today to find out more on how you can give the best protection for your loved ones.
Hello, good afternoon, everyone. My name is Yoni, and I will be your MC for today. So before we start today's event, I would like to check with you all about a few preliminary matters. Like, for example, if you can hear and see me clearly, can you please type 1 in the chat box? Great to hear from you all that everything is working well. Okay, so we are still expecting a few other participants to join us today. So before we actually pass the screen to our speaker, I would like to share with you all about our latest marketing incentives and also make a few business announcements. But before that, right, we have a few house rules to go through with you all. Like, first and foremost, before we start, we would like to remind all of you to mute your microphone to avoid any distractions during the talk. And meanwhile, in between, if you have any questions, you may type it out in the chat box, which we will direct these questions to our speakers, and they will answer it during the Q&A sessions. For best audio experience, you are also encouraged to use your headset or your earphone so that you can hear us clearly. For this workshop, we are actually giving away 2 SF credit points for your attendance, while you may collect another 2 points by completing our questionnaires, which we will post it in our chat box at the end of today's workshop, especially for those senior estate planners. So without further ado, let me put up my screen first, okay, on the business announcement. Sorry, give me a moment. Okay, so let me put up the full screen. So today, right, is Chak Gome and Happy Lunar New Year, okay? And today is also our closing date for February lah, this month lah. Okay, so please make sure that all your submissions have been completed for us to record as your February sales and also to enjoy our February incentives. Okay, and upcoming in March, our closing date will be 31st of March lah. So please take note on the closing date. Meanwhile, currently, right, we are having these incentives for all the new franchisees who are joining us this year. Okay, we are having these zero interest installment plans for 6 months. For those credit card holders of CIMB and also Maybank card holders. So if you come across any prospect that want to join Rockwill as our franchisees, please remember to indicate in the credit card payment form CIMB 6 installment or Maybank 6 installment for us to record, for us to take note on these matters. Otherwise, alternatively, you can also make payment by way of Pay Rockwill's apps, which is a payment apps that we have recently launched, which you can download it on the Apple Store and also the Android Google Play Store. Okay, which this 6 months zero interest installment plan is also available for all Maybanks and CIMB bank credit card holders. So these are some of the benefits that they can enjoy. Not just that, they now will be receiving a free basic will upon their completion of our will and trust training. And if let's say if their will is not a basic will and is more than that, they will just need to top up the relevant will writing fees less the 70% discount as per their voucher. And not just that, they are also entitled to free 1 year RBS membership. Okay, which if your prospect would like to know more as to this, feel free to contact our business division and we'll be there to assist you. And not just that, they can also enjoy cash rebate up to 1,588 ringgit. Okay, and meanwhile, I noticed that there's this question from in the chat box for these new franchisees. Okay, so if let's say they are joining us right now, we are also giving away 70% discount for their spouses' will as well. Okay. So if anything, if your prospect would like to know more about the terms and conditions, they can just inquire to us and we will address to them. Okay, and also your recruiter fees, right? If let's say you manage to recruit someone to join under you, then our recruiter fees have now been increased up to 500 ringgit, which is for senior franchisee, and 350 ringgit for normal franchisees. Okay, so now let's move on to our upcoming activities for March 2021, which I believe that you may have received the marketing activities email from Richard yesterday. So here are some of the events, our upcoming events. So first and foremost, on the 1st of March, we are having an estate planning for digital asset sharing, which is conducted by Mr. Ashar. And unfortunately, due to overwhelming response, this workshop's registration has been closed. Okay, so please stay tuned for our more upcoming events on this. And next, right, we also are having this guide to custody, which will be giving out for senior franchisee credit points. And this will be on the 5th of March. It will be conducted by Angeline. Okay, and next, right, on the 16th of March, we are having this insurance trust workshop, which will be conducted by both Richard and yours truly, Uni. Okay. And then next, right, on the 23rd of March, we are also having this fundamentals of buy-sell trust workshop. And this will be a full day workshop. As you can see, the starting time will be from 9:30 until 5 p.m. And this is also conducted by Mr. Asta. And on the 26th of March, we are having this guide to trust instruction form. And also this will be conducted by Ms. Shin. And on the 29th of March, we are having this guide to recruitment, and this will be conducted by Philip. And last but not least, we are also having this RBS business opportunity presentation, which this will be conducted on the 31st of March by Ms. Yvonne. So if let's say you are interested, or maybe any of your prospects are interested in some of these workshops, you can just register with us by referring to Richard's email. But for the workshop, like fundamentals of buy-sell trust and the RBS BOP, please stay tuned for Yvonne's flyers and also emails lah, which she will be sending us all these. She will be sending us this registration link later on. Okay, and also we are having these monthly activities, which is a public talk for your prospect who are interested in joining Rockwills as our franchisees or REPs. If let's say you come across anyone that would like to join Rockwills, then you can recommend them to come for our 3P seminars, which is on the left-hand side there. As you can see, we are holding one on the 6th of March at 3 a.m. Sorry, the timing should be 3 a.m., 3:30 in the morning on Zoom, which I believe that Chun Hui have already sent out the registration link, so you may refer to Chun Hui's email on that. Okay. And meanwhile, in the middle there, we are also having this will writing presentation, which is a public talk where you can invite any of your prospects who are keen to know about will planning, and this will be conducted on Facebook Live. Okay, so if let's say your prospect they are keen to know about this, then just log into Facebook and go to Rockwill's official Facebook account, and it will be live streamed over there. As for the family trust presentation, we will be conducting this on the 18th of March at 2:30 p.m. at our Facebook Live as well. So if let's say you come across anyone interested in any of our events, just invite them and we will be doing the sharing for them. Also, just to update you on our latest features of REP portal, we have now added in this tab for Knowledge Depository, which just now, shortly before I make the announcement, we have played a few marketing videos and also infographic videos for knowledge purpose or maybe for prospecting purpose. So if you are keen to maybe look up more on our latest videos, feel free to go to this Knowledge Depository tab on REP portal. And last but not least, please help us to like, subscribe, and share our social media accounts. Like for example, we have this public Facebook page called Rockwill's Group on Facebook. So please give us a like so you can always get the latest notification on our upcoming events and also articles and sharings. And in the middle there, we also have this closed Facebook group, which is only available for all estate planners and also our staff, our Rockwill staff. So if you want to add them as friends, please remember to PM them your details. And on the right-hand side there, we also have this Instagram account. Feel free to follow us. And last but not least, we also have this Rockwill's Twitter account and our Rockwill's YouTube account as well. So feel free to just like, subscribe, and share to promote our social media account to create more awareness to the public. Okay, so that's all for my part. That's all for my business announcement. So let me stop my share screen first. Okay, so today we are honored to have with us our CEO of Rockwill's Trustee Berhad, Ms. Shat May, and Senior Manager from Rockwill's Trustee Berhad, Mr. Vincent Yap, to share with us on estate administration matters. So without further ado, I will now pass the screen over to Ms. Shat May.
Hello. Hi, everyone. Okay. Happy to have all of you here. And happy 15th day of Chinese New Year. Okay. We have, what we have today is we have Vincent Yap, our Senior Manager for Legacy Management Estate with us. And he will also be helping me out with the sharing with all of you. Okay, let's see what we are going to do today. Hopefully everyone had a good lunch. And this is what we're going to share with you today. We are going to look into the estate administration's processes as a general overview. And then from there, we'll try to give you a better understanding of what the probate court's procedures are. And other than that, you will hear from Vincent some of the procedures and processes on estate administration and the practical challenges faced by us at Rockwill Trustee. And hopefully you will also be able to take with you some of the state administration fees and other fees that are involved in the administration of an estate. Now, as for you, I hope that at the end of the day, you can actually give us your attention and share with us your questions during the Q&A session. Okay, now let's move on and start our day. First and foremost, talking about estate administration, this is what, after talking to a lot of people and a lot of our own relatives and friends, this is generally what the public think about when it comes to estate administration. Okay, this is the common perception about what the entire estate administration process is. And the thought is, upon the demise of the person, there will be a collection of assets, and some will actually know that the debts need to be paid off, and then there's a distribution of assets to the hands of the beneficiaries. So this is the well-known perception that our friends and relatives usually have relating to estate administration. But ladies and gentlemen, is it that simple and easy? That looks like a three-step process to complete an administration. So it is really that simple and easy. Now let's look at what we do at Rockwill Trustee. What do we actually have to deal with when it comes to administration of an estate? Now, these are the things that we have to look into. Okay, it doesn't look difficult, but this is what happens. We have to look at compliance issues, accounting issues, processes, personal income tax, estate income tax, legal matters, practical challenges, beneficiaries, family members' affairs, income taxes, the court, keeping of records, reporting to the beneficiary, tracing of records, holding testimony trust, and overall communicating with everyone involved. That looks simple. I can say it in one breath, right? Now, the thing is this, if these are all the processes that Rockwill Trustee have to deal with in terms of an estate, and whatever I throw to you here in this particular slide, basically is not in a very coherent manner to you, because the fact is, when you deal with all these issues, ladies and gentlemen, it is really not as simple as step 1, 2, 3. It comes down to you just like that. It's just thrown up to you, and all these issues has to be dealt with concurrently most of the time. There's no such thing as, let me deal with communicating with the beneficiaries first, then I deal with the compliance part and file the personal income tax, and I keep records. There's no such thing as that, because everything else comes to you as one big process. What we do, if you can notice from my slide here, is this. You're basically, as an executor, you're basically taking over the conduct of the deceased person's affairs, and it is going to be every single aspect of his affairs. As I mentioned to some of you before, we are to step into the shoes of the deceased person. We are supposed to deal with everything except sitting down and have dinner with his wife. That's all. The rest of the things we have to deal with, including pacifying any mistresses who may be around. We have to deal with, bankers who might be knocking on the door, chasing for outstanding payments, etc. So these are things that are there and has to be dealt with even upon the demise of a person. So if this is what we have to deal with at Rockwill Trustee, what happens then if, you as an individual is appointed as an executor? So if like that, you're appointed as executor, how? This is what some of the clients, beneficiaries, and individual executors have feedback to us. They think that there's so many things to do, and this is their reaction. They want to go doing, kill themselves, because it's just so many things that is so confusing to them. So Yeah. I'm a vegetarian, so I'm not hanging anything alive. I'm hanging a banana. So yeah, it doesn't really die. Okay. Sorry about that. So basically, the message we're trying to get across is this: an estate administration perhaps appears like it is a very simple process of taking the money from the deceased pocket, paying off some of the credit cards, some of the car loan, etc., and then balance payout to the beneficiaries. Some of the individual executor that I know of actually just take money, straight away distribute. They don't even look at debtors, they don't even look at income tax, nothing. What debtor? The guy is dead, no need to pay. So it is as simple as that. And they forgot about the liability that is actually imposed on themselves, the duty imposed upon themselves as the executor. So yeah, that's why some people actually told us that they might want to, kill themselves, acting as an executor. Now, the thing is this: you do not have to despair. Your clients do not have to despair. None of the testators in Malaysia need to despair because Rockwill's trustee is here. Okay, I am all for Rockwill's, and the reason why you do not need to despair when Rockwill's trustee is here. Look, our duty at Rockwill Trustee is mainly to unburden the family. By talking about unburdening the family, we're actually looking at taking away the burden of having to administer an estate while having to deal with the loss of the testator. We're talking about unburdening the family by actually taking away all sorts of legal paperwork, taxation, accounting issues from their hands. We're talking about unburdening the family because we do not need them to get the emotions involved. So these are things that we will actually be able to do. And they don't have to scratch their head thinking about what is it that I need to do in terms of dealing with the court, dealing with the lawyer. Do I get the right process in place? Am I supposed to distribute now or later? So all these things are taken away from the hands of the family. Now, other than that, we relieve the family from worry. Worrying about what? It's not so much about worrying about whether the things are to be done. One of the main issues we're looking at is the family do not need to worry that the money that they have, that the testator has left behind, is going to be used unnecessarily, or the monies from the testator is going to be distributed to the wrong person. This is something that the family can actually be relieved of. Yeah. And other than that, we are experienced. We do not do anything else. In Rockwill Trustees Legacy Management Estate Department, they don't deal with anything else. There's no selling of products. There is actually no dealing with any other issues except issues related to administration of estate. So that is the only thing that they do. They are very experienced. And in terms of professionalism, I think we will be one at the top, mainly because we actually do have the company as a whole having a policy to actually enhance every single aspect of our work. And further to that, we are independent. And this is a big point that your client should be actually advised upon. Look, the Rockwill's brand has been around. We're in 26 years. What independence we have is actually going to be very much what we have since day one. We do not actually cross-sell products from our side. Okay, we don't have Rockwill's insurance to sell. We don't have a Rockwill's mutual fund to sell. We don't have anything that ties us down. That's one of it. And we're independent because we do not get tied down with a preference. I don't have to prefer one beneficiary over another. We don't prefer the wife over the mistress. We don't. We just follow what the will tells us to do. So this kind of independence is very important, and it gives the testators assurance that we will not take sides when the time comes. And this is something, ladies and gentlemen, that I think is really, really good to share with your clients. It's really, really good to share. Other than that, very importantly, we are here forever. So we are going to be a company that is going to deal with the estate administration. It's not going to be Shadmay, it's not going to be Vincent as executor, or probates state the name Rockwill's trustee as executor, not Shadmay, not Vincent, not any of the other colleagues of ours. And if there is actually any kind of administration that actually requires the administration of a testamentary trust as well, that factor of perpetuality is going to be very important. That means we are going to be here long enough to carry out the administration of a trust. And I think some of you have trusts that deal with, giving away assets to grandchildren who are perhaps very young, and to hold the estate for the grandchildren until they're 25 or so. If that's the case, can an individual be assured to be around to carry out this duty until that time? Yeah, so like in Rockwill's trustee, we are independent, we're perpetual, so we can actually deal with testamentary trusts that actually last for 40 years. We actually have one in our hands which is for 40 years. So we are just halfway through. It's less than halfway through actually. We are just like 10 years into administering that testamentary trust. So there's another 30 years to go. Shadmay will probably die in 30 years' time. Hopefully not, but yes, there's a possibility. So when that happens, Rockwill is just going to employ another manager to take over the job. The case will go on. There's no necessity for Shadmay to be here. Hence the importance of having an independent and perpetual entity dealing with the administration of the estates. Okay, so that is why Rockwills. And if we are recommended as a sole executor, okay, of Rockwill's trustee, there are a few factors that will actually prompt our testators to do so. Now, what are those factors? It will be this. If you see that the clients actually have a very complex set of beneficiaries, I'm looking at, I'm not a sexist, I'm not pro-men or pro-women, but a lot of men actually have mistresses. Okay, I've just offended the men. Okay, some men actually have mistresses. Okay, some women have boyfriends outside their legal marriage. Sorry about that. But what happens is that when that happens, they may want to take care of the mistress or the boyfriend's family and children who are probably born outside the legitimate family. This is one of the common scenario that can happen, where it might be good to put an independent party like Rockwill's trustee into the picture as the executor. So imagine if giving a set of powers, executorship powers to the wife, and telling the wife to please take care of my mistress, the woman who actually took me from you, kind of thing. So that is not going to work. That is not going to work. So this is where you have to look into how the beneficiaries' relationship should be considered at the point when the testator is advised about appointment of an executor. So it's not just telling the client, you got wife, right? The wife can read and write English. Okay, appoint lah. No, it's not just that. It has to be, would the wife be able to handle the pressure of handling this? Or I have some clients who tell me, my daughter is a lawyer. She's a lawyer. She definitely can do this job. I'm very sure she's more than competent to administer the estate. But would she have the time? That is very important as well. So looking at all this, who are the beneficiaries, how this relationship are between the family and the beneficiaries is going to make a difference. So when the complex situation is an existing condition, tell the testators you don't have to think very far, appoint Rockwill trustee as the executor. And the second thing is if there's a complex set of assets, this will be assets that are actually sometimes jointly owned. They could be assets that are actually properties, it could be commercial properties, it could be management of some plantation lands, etc., that requires a little bit more technical knowledge. Yeah, this is where we can come in. There could also be investments that requires monitoring. Okay, and of course, as I mentioned just now, if there's a testamentary trust, we should come in. The client should be advised clearly that if there's a testamentary trust, name us as the executor, because you wouldn't want the testamentary trust to be carried out for a short while and then the executor pass on as well. Now, next up, ladies and gentlemen, if the testators, the clients, do not wish to have us as the sole executor, always prompt the testators that they should at least name us as a substitute executor. This is a safety net, just in case the main executor or the first few individual executors cannot carry out the job. At least then, Rockwill trustee can come in quite immediately. Okay, with that, I want to now look into the situation where we are already appointed as the executor, but upon the testator's demise, what's going to happen? Now, we at Rockwill trustee will not have the opportunity to meet the clients or the testator before his demise. This is a very unfortunate situation, but we will not be able to meet them. But once the testator pass on, we will need someone to trigger Vincent and his team as to what needs to be done. So the triggering has to be done by either the family or a friend of the deceased or you as the franchisee of the testator. Now, how do you go about doing that? We can actually have these very simple steps, okay? You just, the moment you are aware of the testator's passing, get hold of a copy of death certificate, okay? And from there, make sure you contact us. We have a dedicated legacy management department. We have a dedicated email address, the one that is in red. And once the meeting is arranged, you might also be helping us collect some documents. We will advise as to what needs to be collected. And lastly, please do attend the will reading sessions that we conduct with the beneficiaries, because it will give the beneficiaries some comfort that the person who actually wrote the will for their loved ones is also there to listen to what's going to happen after they pass on. So this is a very simple three-step process to report the testator's death to us. So this is actually pretty simple, okay? Nothing too complicated. If I could just, I may have gone too fast. Is there any question related to the matters above that I can address?
Yes, we do have one question from the in the chat box. There's this RP that asks, are the estate planners allowed to attend the will reading sessions?
Yes. In fact, Yoni, thank you for the question. In fact, we would actually encourage our franchisee to attend. This will actually give them, like I mentioned just now, it gives the beneficiaries an assurance that, you know, this particular franchisee is there, knowing what happened to the testator, and continue to be involved in the administration processes by just being there. And over and above that, the franchisees, especially those who are actually family friends, those who actually know the family, it will be good to be there to actually give them moral support as well. It's actually very important. Thank you, Yoni. Any other related question, Yoni?
Let me see. Because as of now, there's only 3 questions, while another one is also from the same estate planner. He was checking if, since Rockwills can only comes in to handle the estate administration only when the original executors resign from their roles. I think he's referring to the main executor. So is there any transition time involved before Rockwills can act as the substitute executor?
As in, is there a transition time, you mean?
Yes.
I don't really get that. If just perhaps I just can share a scenario. If, for example, we are named as a substitute executor, then the first there is a first substitute as well. So the two main person who is actually appointed as the executor will have to renounce their rights first before Rockwills can actually act. So regardless of how long a fight they're actually involved in, the fight must be completed first before they can decide whether they want to continue or they actually want to actually renounce their rights to act. For as long as the first named executors or whoever is named before Rockwill trustee, for as long as they have not renounced their rights, then Rockwill trustee do not have a right to act. Would that answer the question, Yoni?
Yes, I think that would be it. If let's say the estate planner still need clarification, I think he can also type in the chat box. So we will address it later on. Well, meanwhile, we have these questions from Vincent Yap. He was asking if can Rockwill estate planners notify Rockwills about the death of a testator without having the death certificate?
Yes, they can notify us so that we are actually aware of it. What we will need to do then is we will still need to secure a copy of the death certificate to confirm the death. I think most of you would be aware when you want to actually help the testator's executor to retrieve the will, they will need to supply the death certificate of the testator. This is to confirm that it is the right party and the right situation to release the original will to the executor. Same thing, if Rockwills is the executor, we will also still have to prove that the deceased has passed on before we can retrieve the will and start acting. So in that situation, Vincent, you can actually send in the notification to us first. What we will do then is we will try to liaise with the family member where we have the contact to actually get hold of the death certificate. If not, the best person to do so could be you as a franchisee. And of course, there are situations where there are dispute and the party holding the death certificate refused to actually release it. So what you do is you just inform us. We will have our way to actually then try to get hold of a copy of the death certificate. But you just have to notify us first. Is that all right, Vincent? And Yoni?
Okay. Thank you, Shammi, for your questions. And we have another one. This estate planner, Sam Seong Tav, is asking if any of the beneficiaries who is currently located in overseas and he is not able to attend the will reading sessions. So what will be our next step for these beneficiaries?
Okay. Now, what happens is that previously, before the good old days before MCO, we will always conduct face-to-face meeting as much as we can, mainly because it gives more assurance to the beneficiaries. So we'll travel to meet them, or the beneficiaries will travel and meet us. We can have separate meetings with the beneficiaries and family. But now, because what we do is we actually conduct only online meetings. We do not conduct face-to-face meeting anymore since the beginning of this pandemic. So all our meetings are actually held online. So even if they're overseas, they can still attend. If they cannot attend at that time due to the time difference, we will still try to arrange for one session where it's suitable for both parties. Okay? Yes, Sintat? I hope that's answering your question. Yoni?
Okay, thanks. Thank you, Shamay. Meanwhile, in addition to the question as to the death certificate, should the death certificate be certified true copy or just a copy, a plain copy of the death certificate will do?
Okay, as of now, I think you will need to submit to custody a certified true copy. What happens is that if Rockwill's trustee is the executor, you can give us a copy of it without the certification. When we receive the original, we will actually certify it at our end. So we will do the certification, but the copy must be given to us first, and we will collect the original from the family when we meet them, or we will get them to actually courier it to us.
Okay, and also we have a few questions from a few estate planners, but in the end, they are asking the same matters, which is on renunciation. If let's say Rockwill, we are substitute executor in their will, but maybe their main executor would like to carry out with the probate application first. But in the midst of the estate administration, can the executor renounce halfway so that they can pass it out to Rockwill to take over? And is there any charges incurred for this process?
Okay, I think there are two levels to it. Legally, yes, it's still possible. I'll just try to make it as simple as I can. So legally, yes, it's possible for an executor who has been granted the grant of probate. We don't call it renounce the right. We will have to revoke the grant of probate. So yes, that's possible. But once they revoke the grant of probate, somebody else will have to apply again to act as administrator with will annexed. So they're going to get LA with will annexed. Next portion of the question is whether Rockwill's trustee can take over. The answer is a very lawyer answer. Depends. It really depends, Yoni, because there are some estates where it's suitable for us to take over and clean up. There could be some actions that were inappropriate taken by the earlier executor. We can still do the cleanup. But there are certain estates that we could not actually do anything, mainly because there could have been no records. So if those are the cases, then we may not be able to take over. So it's really a case-to-case basis that we are considering. Have we done it before? Yes. Are we willing to do it again? Possible. Thank you, Yoni.
Okay, thank you, Shamay. And would you like to accept another questions or?
Yes.
Would you like? Okay, one more question, huh? Okay, so we have this question from Su Ann Lim. She was asking, how often will Rockwill update the status of estate administrations to the Rockwill estate planner?
To the estate planner. Okay. Usually to the estate planner, it also depends because some of the beneficiaries, when we actually first meet them, we will usually ask for an authorization from the beneficiaries to update the estate planner. Some of the times they will actually say, yes, I will grant the right to the estate planner to receive updates as well. This will be a watered down version of the updates. Sometimes they will actually say, no, just keep the estate planner out of the picture. So if they actually allows it, if they actually authorize the estate planner to receive the information, then we will actually pass to them like in a quarterly basis. But it also depends as well because we have a few cases. Actually, we have quite a number of cases where halfway through the beneficiaries also change their mind. When earlier on they say yes, then they say no, stop giving information to the franchisees. And similarly, there are those that did not give consent to the franchisees to receive the information. Then halfway through ask us, why didn't you update the franchisees as well? So, but generally, it will be on a quarterly basis. But we have, since the last quarter, been moving forward towards getting bi-monthly status updates out to the beneficiary. So once the information goes to the beneficiary, the information should go to the authorized estate planner as well.
Okay, thank you, Shamay. So, Shemay, would you like to proceed with your presentation first, or would you like to accept the questions from the floor?
Perhaps what I'll do is, I think we have taken quite a lot of relevant questions with regard to this. I will actually move on now. If possible, all the questions we can still consider at the end of the Q&A session.
Yes, that would be great. So for the questions left unanswered, we will be answering these during the Q&A session later. Thank you.
Okay, thank you, Oni. So, in fact, so just a quick recap. So what happens is that if we look at the general perception, perceiving that the estate administration process is a very simple process of collecting assets and then making distribution to the beneficiaries. And then in actual fact, there are actually quite a number of things that we have to look into, that needs to be done quite simultaneously. And we're looking into situations where it's suitable to recommend to our testators when to appoint Rockwill trustee as the sole executor. And we also looked into what happened if the testator has passed on, how you as the estate planner can actually then help to notify us of the death. So this is where we are right now. So when we are notified of the death, what do we do then? Now, as of now, I will actually pass the floor to Mr. Vincent Yap. This is our Vincent Yap Ming Cheng, not our franchisee, Mr. Vincent Yap. Okay, this is our Senior Manager of Legacy Management Estate Department, Mr. Vincent Yap. He will share his experience with you with regard to what estate administration process are, so that you can actually learn a bit about what we do at our end and what are some of the challenges that we actually face. Okay, so if I could just share this. Over to Vincent.
Hello, thank you, Shemay. Good afternoon, everyone. I'm Vincent. I'm in charge for Legacy Management Estate Department. Moving from what Shemay has explained earlier, what happened after we reported the death reported to us. The first thing that we will usually do, hang on a second. All right, the first thing that we will do after the death reported to us is that we have to start locating and retrieving the last will and testament. When the death certificate are submitted to us, we will need to then submit it to our custody department and verify that whether the original last will and testament is in our custody. If it's yes, then we will send out an instruction to our custody department to release the original last will and testament to us. But if it's not in our custody, then there will be a very long process that we have to do investigation and also to locate the original last will and testament. So the process can be a very long process. Reason being that, as the testator, sometimes they kept their will in secret. They kept in their safe deposit box. The family member usually what they do is that they don't know. They don't know what happened. They don't know where the deceased kept their will. So if that happened, it will be very difficult for us to actually start and commence the work. Worse still, if the testator actually kept their will in the safe deposit box, we cannot actually retrieve the will without a grant of representation first being obtained. That's why if you are the franchisee, try to recommend the lifetime custody and lifetime plus custody to the testator so that the will is kept with us. Then we can actually skip that problem to prevent those obstacles in getting the original will. Okay, if you don't know what is lifetime custody, you can actually PM us. I can actually get our trainer to actually talk to you about these packages. Okay. What happened after that? What happened after we get the original last will and testament? We will then have to arrange a meeting with the beneficiaries and family members. The main intention in arranging this meeting is basically first to tell them that what can you expect to receive from the estate? Right? Read out the contents to them, tell them that you're going to receive this asset from the estate. And also more importantly, we have to, in this meeting itself, explain the processes, procedure, as well as our duty as the executor to the beneficiary. As what has been emphasized by Shemay earlier, the common perception of the public is that it's just a very simple process where you just collect the asset, you pay off the liability, distribute the remaining to the beneficiaries. This is in their mind is that it's very simple. It can be done just within perhaps a few weeks, a few months, or even shorter periods of time. So we will then have to, in this meeting, manage their expectation. Tell them, look, it's not as simple as that. All right, there are a lot of processes, a lot of duty, a lot of rule, and a lot of law that we have to comply with in order for you to even receive the first asset. So after that, another thing that we will do is that we have to also gather the relevant information and documents from them. All right, this is what happened, why we need to do this in this meeting. A lot of will actually written a long time ago. It can be written like 10 years ago or 5 years ago. It's not updated. It does not reflect the latest financial position of the testator. So it could have, within these 5 years, in these 5 years or 10 years, the testator could have, purchased another properties, open another bank accounts, purchase another insurance, sign up another insurance, etc. So the will wouldn't reflect that. There could be a situation that even the will just has a residuary clause. We say that I give everything, but it didn't give us any information. So when we see a will like this, it's very important that the family member in the first place they would have better knowledge about what are the assets that we can actually look into, what are the properties, what are the liabilities, debts, etc. So in this meeting, we ask them. And also very importantly, we will have to tell them, look, engaging Rockwill's services as the executor, there are fee incurred, right, which is chargeable to the estate. And also there are expenses, there are other third-party expenses. I think you all are very familiar with the estate administration fee. You'll be very familiar with this. The estate administration fee, let me just quickly go through. We are charging our estate administration fee based on the gross estate value. It includes both movable and immovable assets, meaning that money in the bank accounts, motor vehicles, properties, all those value, we will charge based on a certain percentage, and is charged on per annum basis after we obtain the grant probate, starting from the times that we obtain the grant probate. The first million, the scale fee is like this. The first million, we are charging 1.8%, and is subject to minimum of 5,000 ringgit. For the next 9 million, meaning that above 1 million, whatever is remaining up to 9 million, we charge 1%. If the value, the gross estate value, exceeds 10 million, the remaining above 10 million, we will charge 0.5%. Right, and it's chargeable on per annum basis. Okay, let me move on to next slide. Okay, there are situations where the testator in his view asks us to hold on to certain asset for a very long period of time. It could be 20 years, like what Shemay mentioned earlier. We have actually a testamentary trust for a period of, will last for a period of 40 years. So for these 40 years, we will not be charging the estate administration fee, which is in a higher percentage on the gross estate value. So once the asset is actually transferred from the estate to the testamentary trust, the testamentary trust commence, the fee will then stop on that particular asset. The fee will then stop for estate. We will then start charging our scale fee based on the testamentary trust administration scale fee. The scale fee is different. For movable asset, the first million will be on the 0.75%, and it is also subject to a minimum of 2,000 ringgit per annum. And the next 90 million is 0.5%, value exceeding 10 million, 0.25%. My line is a bit bad, so hang on for a second. Alright, for immovable asset, it will depend then whether it is income bearing or non-income bearing. Income bearing meaning that there is rental, so it's generating income. For rental, property with rental, we will charge based on 1% of the gross value of the property, or 6,000 ringgit, whichever is lower. Meaning that if it's 500,000, the property is worth 500,000. The 1% of the gross value of that particular property will be 5,000 ringgit. Then 5,000 ringgit and compare to 6,000, 5,000 is lower, then we charge 5,000 ringgit per annum. And for immovable asset that is non-income bearing, we will charge 2,000 ringgit per title. Meaning that if you want property with one title, then we charge 2,000 ringgit. Okay, over and above the estate administration fee, those are the fees that payable to Rockwill, is paid to us for our services as the executor. But there are also possible expenses and also third-party fee and charges. It's very important to highlight this to the beneficiaries or to the testator when you're writing a will, preparing a will for them, getting instruction. You have to tell them that over and above the estate administration fee, there are expenses that you cannot avoid. For those expenses that you cannot avoid, we can actually list down here. You can see that there is legal fee for application of grant of probate. These are the legal fees that we pay to lawyers to apply for the grant of probate in court. And there is also advertisement fee for notice to creditor, the ones that pay to newspaper. And then we have tax agent, income tax filing fee, tax clearance fee, accounting fee. These are fees that cannot avoid for administration of estate. These are the third-party expenses. And on top of that, we have others expenses that is possible, that's possibly will incur. Example will be, all right, if you can see here, there is land and local authority taxes, meaning quick rent assessment. You have cukai tanah, cukai takseran. These are expenses. Legal fee for transferring of property. If the estate consists of property, then you have to pay that to get a lawyer to transfer the property to the beneficiaries. Then you have property transfer fee to land authorities. That one is the registration fee you have to pay to land office. You have valuation fee, where we have to value the property. Property agent fee, if you are looking for selling the property. For example, the will say that the executor will have to sell the property and distribute the net proceed of sale to the beneficiary. Then if there is no buyer, then we will have to look for a property agent to look for the buyer, to source for buyer. And that will incur. Then we will have vehicle inspection and transfer fee, and if there is a motor vehicle, as well as other third-party service provider expenses. Other third-party, there are a long list. We will have brokerage charges if there are listed share, company secretary charges, stamp duty, etc. These are expenses, depends on case-to-case as need basis, it will incur. Right. Okay, if you look at the previous slide, when we do this will reading, we call it the will reading, the first meeting that with the beneficiaries, right? You wouldn't actually see them smiling, right? Although they are accept. Hold on a second. Just drop. All right, sorry. Yes, let me. Okay, never mind. Sorry, there are some technical issues that I have to sort out. Hold on a second. Okay. Okay, thank you. All right. Okay. I was talking about the will reading session. All right. What happened is that during the will reading, usually we will not see happy face. When they come, the first face that we will see is usually they will come with a very sad. They will show a very sad face, right? Someone has passed on. Some of their loved one has died. So during the will reading, we can see them, crying, wiping tears. But other than that, also sometimes we will see them being angry. Why? When they hear about the estate administration fee, right? When they hear about the estate is going to be in charge by someone that don't know, and then these are their father's money, these are their mother's money. How come that an outsider will have to actually step in and administer the estate, right? It should be handled by me. So we will also see a faces a very grumpy and angry faces during this meeting. So it's very important for us to remain as a professional to deal with the emotion of the beneficiaries during the meeting, not to scream with them. It's very hard for us to actually scream together with them because we have to remain professional. If we scream with them, we can't move on with the administration of the estate. A reason being that the cooperation from the beneficiary is also very important. We have to relate to them during this meeting. Okay. When I mentioned earlier about when we do will reading, when we conduct the will reading, we have to gather information in relation to asset and liabilities from the beneficiaries and the family members. But sometimes it's not. Sometimes they do not know what the disease actually own and what kind of debts that the disease is owing to others, bank, housing loan, whether there is any other bank account with other banks, whether there is any other insurance policies assigned to him, owned by him, that kind of thing. So at our side, when the information is not available to us, the first thing that we will do is that we will also conduct our own searches. We will write to the bank, all right? We will write to the KWSP, the insurance company. We will do land searches. We will also write to the investment company, as well as we will also do company searches or other third parties. All right. For banks, the first thing we do when we receive the death certificate, we will have to send it over to the bank to ask them whether the deceased has any banking relationship with them. Right. what the response that we receive is usually a bank account number, how much is in there, whether it's a joint account or whether it's a sole account, the type of account, right? These are the information can be released by the bank to us. Right. There is also insurance. For insurance company, we will be looking into whether the insurance is owned by the deceased or whether the insurance is owned by someone else and the disease is a life assurance and that kind of thing. And land searches is also very important. When the family member told us that there is this property owned by the deceased, but they cannot produce the title, right? At least we need to do this land search to ascertain the ownership of the deceased, and at the same time find out whether there is any caveat, there is any charge, owing housing loan and all that. It can be found out from these land searches, whether it's jointly owned with other joint owner. Investment company, same thing as well. We do searches on unit trust, mutual fund, bond, etc. Company search is on the non-listed share, the Sdn Bhd shares. We will do that to see how much share is owning by the deceased, right? Other third parties, right? Why do we need to deal with other third parties? You see, the purpose of it is not only to gather information on the asset. We have to also gather information on the liabilities, right? At this stage, we can already start determining the liabilities. When we write to third parties is when the beneficiaries or family member told us that, disease actually lend some money to these people, or the disease has borrowed some money from someone, then we have to actually verify that. We have to write to them, call them and assess the documentations in relation to that particular debts to find out and ascertain. This also is to prevent having asset or liability being left unadministered at the end. Well, normal people would usually not do that, simply because that they don't have the resources, they don't know where to look, right? If it's bank, there are so many banks in Malaysia, there are so many insurance companies, so many type of investment, right? Company searches, land searches, should I do it or shouldn't I do it? How do I do it? Beneficiary will not know that. If you go and ask for a lawyer, right? I say some lawyer, they are just the information that they gather is usually just gathered from the family, right? They ask the family member, right? Tell me what are the assets. They don't do the searches, right? We Rockwills, one of the things that you can sell is that we will do searches. No matter whether there is the family member tell us that there is no bank account with Maybank, we still write to Maybank to confirm. Even me myself, I cannot recall whether I have my bank account with Maybank is still active, whether it has been closed or has not been closed. Even me myself, I don't know. The bank would know. So that's why we will write to them to confirm that and get a confirmation on that. Simultaneously, when we do the searches, we will start the process to apply for the grant of probate. For applying the grant of probate, what we need to do, we have to engage a lawyer. This cannot avoid. Right? We have to engage a lawyer. There will be a process of the lawyer drafting, vetting, and finalizing the cost papers. The cost papers, if you see here, there is a list of asset and liability, list of beneficiaries, and affidavit. Right, let me explain in detail. For list of asset and liability is one of the documents that we have to submit to court to support the application. It's by way it's an exhibit. In the list of asset and liability, it will list down all the asset and the liabilities. It's very important that this list of asset and liability, this listing has to be complete. Why? If there is one property that you left out and didn't actually put in this list of asset and liability, when you go to the land office and want to transfer the property, it wouldn't go through. It will be rejected by the land office. They will insist that this property detail to be listed in this list of asset and liability. Then that is when that we have to spend more time, incur more time and more costs to go to court again and apply for an amendment, to put in an application to amend, and that could go on for months. Hence, to prevent all that, we do the searches in the beginning and make sure we have the complete information before we apply. And then you have this list of beneficiary where you look at the will and who are the beneficiary. You have to identify them and tell the court. And affidavit. This is also the affidavit. You will have to be signed by the executor, Rockwill's executor, and also the witnesses of the will. All right. We will usually send the witness affidavit to the witnesses, and then they will have to then go to the nearest commissioner for oath to sign it before the commissioner for oath, then send it back to us. After we receive the signed affidavit and all that, we will then file it through our lawyer. We will then submit it to the court, and hearing date will be fixed by the court. During the hearing date, the beneficiaries, witnesses, they all don't have to attend, do not need to attend. Only us, executor, our representative, we will go together with our lawyer to the court to attend the hearing. Once, if everything is in order, then the grant of probate will be granted by the court. Then we will then have to wait until we receive the physical copy of the grant of probate. Extraction, we call it an extraction of the grant of probate from court. The whole process can go on, from 3 months to 6 months. It depends. Sometimes it could go beyond 6 months. Reason being that the documents does not make available to us, or sometimes that especially for example during this pandemic time, MCO, the court closed, right? Earlier on, the court closed, all the cases has been adjourned to a further date. So how fast we can get the grant of probate? One, how fast, it depends on how fast we can gather all the information. It depends on how fast, how soon the court fix the hearing date. Okay. After extracting the probate, then what we do? We will have to start running already, because from this moment onward, our estate administration fee will start to charge, will start to commence. All right. The first few things we'll do, one of it is that we will have to advertise notice to creditors. For notice to creditors is a statutory duty. Literal meaning is that we have to give notice to those possible creditors and tell them that, looks, if the deceased owe you money, right, please, we are the executor, come forward and submit your claim. All right. This is one, importantly, is to eliminate the potential liability of the estate and also to prevent dispute. What happened is that if you don't do this, all right, after you distributed someone's everything, then certainly someone turn up and tell you that, look, the deceased actually owe me a lot of money, and then you didn't tell me that he died, and then you didn't tell me that he passed on. I want to submit my claim now. Then you will be in, as the executor, we will then be in a very difficult situation. So in West Malaysia, usually we will advertise for 1 day, but we give a grace period of 2 months for them to turn out and submit their claim. So in these 2 months, there will not be any distribution made. After that 2 months, then only we are free to actually do distribution. In East Malaysia, Sabah, Sarawak, is usually 3 months. Another thing that we have to do is we will have to write to Inland Revenue Board, right? Simultaneously, we will write to Inland Revenue Board, LHDN, to ascertain the personal income tax status. We will have to ask LHDN whether there is any outstanding tax payable, any years of assessment, any years that the deceased did not file his income tax, right? If so, then we will have to pay that. Right? We will have to file it up to the deceased date of death. Then another thing that we will do is we will start collection of asset. Right? For collection of asset, the meaning is that we will start go take the probate and go to the banks, right, and go to the insurance company and tell them that, look, we have the grant of representation, give us the money, all right? So the common type of asset that we have is usually a cash in bank account. We have property, we have vehicle, we have a unit trust or mutual fund, listed or non-listed share, we have insurance, safe deposit box, investment, and businesses. These are the common type. It does not limit to this, and then there are other things as well. Okay, so for cash in bank account, like what I said earlier, we will forward a copy of the grant of probate, a certified copy of the grant of probate, together with an instruction letter to bank and tell them to release the money. All right. When we receive the money, it will be deposited into a specific bank account we open for every single estate. All right. This is also one of the selling point. For executor, if Rockwill is the executor, we keep every single estate, we keep a separate account. Right? The monies that we collected, it will be deposited into this bank account. Whatever that expenses has been paid out, it will be paid out from this account as well. So it's very straightforward. Money comes in, money goes out. But if you are engaging an independent individual to be the executor, usually what they do is that the money comes in, they deposit it into their own account. So if they don't prepare a proper account, they wouldn't know that money actually belong to me, or is it belong to the estate. This is one thing that, the mistake of an individual will do as an executor. For Rockwill, we don't have that problem. Right? We maintain a specific account for every single estate. For unit trust fund, same thing. We will look into the view and see whether we have to redeem it or whether it's to transfer it. Then we will deal with the investment company. Listed or non-listed share. For listed share, we deal with Musa. We open a CDS account. We transfer the share from the CDS account, the disease CDS account, to the CDS account we open for that particular estate. Same thing, we open a specific account for that estate to receive the listed share. Then you have non-listed share. You have insurance, same thing with claim insurance. The most interesting one would be the safe deposit box. The safe deposit box. All right. When there is if we discover that this is own a safe deposit box with let's say a public bank, then we will have to actually deal with public bank to get the date, and we will go to the bank together with the beneficiaries, all right, as the witness. Then we open the safe. The obstacle that we have for safe deposit box is usually the key is not locatable, right? The family member don't know where the disease kept the key and all that. Then we will have to actually get someone to drill open the safe deposit box. There are a lot of interesting things that we can actually find out from the safe deposit box. We will have like, a lot of photos of different women with the disease. Sometimes the interesting one, even there is this one time we saw that there is an umbilical cord in the safe deposit box. Sometimes there are a lot of jewelry and all that. Sometimes it could be something that is not valuable at all. Okay. And then there is investment, there are businesses. So what happened after we receive the money? When we receive the money, after we receive the money in the bank account, we will then starting to look into paying off those debts and liability. For payment of debts and liability, the most common type one that we will see is the funeral expenses, the estate administration cost, yes, our fee, and the expenses of in administering the estate is also one of the liabilities. And then you have income taxes, you have housing loan, you have personal loan, you have guarantees, you have credit cards, hire purchase, and as well as assisting legal suit in court, or legal judgment sum. Let's say you owe someone monies, and then there's a judgment against the disease, and then when we become the executor, that the estate will then have to pay off that judgment sum. Right? It has to be paid according to priorities. Right? The priorities is always funeral expenses, then estate administration fee. Why? I would say that when someone died, when someone passed away, all right, the first thing what you need to do, you have to bury him. Right? You cannot leave him there. So there must be money, out from the deceased's own pocket to bury himself. So funeral expenses is the first one, priority. Then someone then will have to administer and look after the estate, right? So that's why the second priority is always, estate administration fee expenses. These are expenses is necessary to incur. Without these two, right, you cannot pay off the rest. Income taxes and all that. Without someone actually administer the estate, how can the income, who is going to pay off these income taxes? So estate administration costs. Then statutory duty, statutory liability. You have income tax, all right, you create an assessment. And income tax is very important. This is like a biggest loan shark in Malaysia, right? Why I say it as a statutory duty? Because if you don't pay it, you could go to jail. So income taxes, as an individual, sometimes they don't think that it is important, but it's very important. If you don't do it properly, you don't get a clearance from LHDN. The LHDN could be 10 years after they discover, when they're doing the audit, they discover that this person passed away. Then they see that you are the executor. They come and look for you and ask you, hey, the deceased owe me money. The deceased actually owes certain amount of income taxes. It has not been paid, and there are penalties to it. 10 years later, the penalty keep on increasing, and then up to the time that you want to pay it, it could be 100 over 1,000. Right? We have cases where we administer the income taxes is 700,000 of taxes that we have to pay out from the estate. But luckily, the estate got a lot of cash, so we do not have problem at the time. Then you have housing loan, right? Housing loan, as in if you don't pay it, then these are secured liability. After income taxes, then you have to look into housing loan. If you don't pay the housing loan, they foreclose your house, go and lay long your house. Then you have those unsecured liability, personal loan, guarantees, credit cards, hire purchase, as well as assisting. Okay. After the liabilities are settled, everything has been paid off, we could then look into distribution of asset. When we do distribution, very important, the first thing we do, go back to the will, right? Who is supposed to inherit what, and then what this asset is belong to the residuary, or this asset is supposed to give to someone, and that kind of thing. We have to look at the provision in the will, right? Then from that, we will then act accordingly, whether to transfer the properties, transfer the investment, or we distribute, we sell it, we redeem it, or otherwise, if the will asks us to hold on to the asset, don't give to the son first. The son is spending a lot of money, so I'm concerned that if I certainly give him 400,000 or 4 million, he will spend it all in 1 year, that kind of thing. So ask us to hold the monies on testamentary trust, give him maintenance for periodically basis and that kind of thing. So we will look into the will and act accordingly. So now I come back here with so many legal, technical, accounting, taxation, paperwork issues. Can executors skip some of the steps? Can? All right. Cannot lah. Definitely cannot. Because those things that I mentioned earlier, everyone has to do. The same thing has to do, right? Legal wise, if there are legal dispute, you have to look into the legal aspect when you administer and state whether I do this is according to the correct rule and regulation. Technically, you have to have the technical knowledge when you want to, file income tax, whether you have already done everything and you don't know, then cannot do. Accounting, are you an accountant? If you're not an accountant, you have to engage an accounting firm to prepare account. Documentation keeping is going to be crazy. Then you have to look at taxation aspect, paperwork issue as well. Lots of paperwork. If you look at transferring of properties, redeeming an investment, transferring or selling shares and all that, the paperwork is a lot. Our file usually goes up to 2-3 boxes for one file. So can an individual executor to actually handle so much when the person passed away, when the disease passed away, the family member are in mourn, right? They are mourning, and then there are so many responsibility actually lie on their shoulder. So can they do it? I can tell you it's very difficult. It's going to be very, very difficult. That's why you need Rockwill to be your executor. Okay. So statutory duties of executor. There are, why I say the statutory duties I mentioned earlier is that if you don't do it, you're going to jail